Good afternoon, everyone, and welcome to part 2 of my lecture series in criminal procedure. This afternoon, we are going to discuss about complaint or information. So let me share my screen to you. Okay. Now, yesterday, we learned about how to institute a criminal complaint. How a criminal complaint is filed in court. We also learned about jurisdiction, the definition of jurisdiction, or criminal jurisdiction, and then how the court acquires jurisdiction over the subject matter and jurisdiction over the person of the accused. Now we go to the sufficiency of complaint or information. Now, what is the distinction between complaint and information? A complaint is a sworn written statement charging a person with an offense subscribed by the offended party, any peace officer, or other public officer charged with the enforcement of the law violated. Whereas an information is an accusation in writing charging a person with an offense subscribed by the prosecutor and filed by him with the court. From the definition of a complaint, you will see, class, that a complaint is prepared by a private person, while an information is prepared by the public prosecutor. Now, from the definition, you will notice, class, that aside from the fact that a complaint is subscribed by the private offended party, that subscription is done before any peace officer or other public officer charged with enforcement of the law violated. This means, class, that a complaint is subscribed before, for example, the policeman or a public prosecutor, or it can also be notarized by a notary public. Whereas an information is subscribed not by the private offended party, but by the public prosecutor himself, and he is the one who filed it in court. So that is the basic distinction between a complaint and an information. A complaint, again, is prepared by a private offended party or private party or the private complainant, while the information is subscribed by the public prosecutor himself. Now, the complaint contemplated under Section 3 is different from the complaint filed with the prosecutor's office. Okay? It refers to the one filed in court for the commencement of criminal action, such as the private crimes. So, class, you remember the private crimes: adultery, concubinage, seduction, abduction, and acts of lasciviousness. So this is the one referred to under Section 3, the one directly filed in court. It is subscribed by the private offended party. Okay. What is the form of a valid complaint or information? Now, the complaint or information filed in court must be in writing. No, there is no such thing as an oral complaint or information. It must always be reduced to writing or reduced in writing. And that a complaint or information must be must be brought in the name of people of the Philippines. No? You learn in your study of criminal law that a violation of penal law or an offense or a crime is a violation of the peace. And therefore, every criminal offense, every criminal complaint is brought under the name of people of the Philippines. Which is why, class, if you see a complaint or information filed in court, the title or caption is People of the Philippines versus X, the accused. Now, because if a valid complaint or information is brought in the name of the people of the Philippines. No? Third, it must be filed against all persons responsible for the offense involved. Now, how do we know that a complaint or information is sufficient? Now, a complaint or information is sufficient if it states the following. Number one, it must contain the name of the accused. It must contain the designation of the offense given by the statute. Third, the act or omission complained of as constituting the offense. Fourth, the name of the offended party. Five, the approximate date of the commission of the offense. And six, the place where the offense was committed. So this class is a rundown of the contents of a complaint or information. Number one, of course, the name of the accused, the designation of the law violated, and the specific act or omission complained of as constituting the offense. It can also include the name of the offended party and the date of the commission of the offense in approximation or its specific date if available, and then the place where the offense was committed. Okay. Now, in case of variance between the complaint filed by the offended party and the information filed in court in crimes against chastity, the complaint control. Now, class, sometimes it happens that the complaint filed by the private offended party is different from the information filed by the public prosecutor. Now, in case that there is a variance, when you say variance, there is a difference or perhaps a mistake in the filing of the information or the contents of the information versus the complaint, then the rules provide that the complaint will be the one to prevail in crimes against chastity. Now, how about the name of the accused? The complaint or information must state the name and surname of the accused or any appellation or nickname by which he has been or is known. If the name cannot be ascertained, he must be described under a fictitious name with a statement that his true name is unknown. Now, class, this becomes problematic if, for example, the name of the accused is unknown to the private offended party and also to the police officer. If the name is unknown, question, can you still file a complaint or information? The answer is yes. Now, what will you include or indicate in the complaint or information? Well, if the name cannot be known or ascertained, then you can include a fictitious name. For example, John Doe or Jane Doe. If the accused are plural, you can indicate John Doe's or Jane Doe's. That is a fictitious name. No? And then you will include a statement that the true name of the accused is unknown. Okay. Now, if the true name of the accused is thereafter disclosed or appears in some other manner, then such true name shall be inserted in the information or complaint in record. In other words, class, the real name of the accused is not an absolute requirement. If the name cannot be ascertained, the complaint or information would still be sufficient if you will use a fictitious name, for example, John Doe or Jane Doe. Or if they are plural, John Doe's, Jane Doe's. Okay. Now, when an offense is committed by more than one person, all of them shall be included in the complaint or information. Now, what if there was a mistake in the name of the accused? Now, a mistake in the name of the accused is not equivalent and does not necessarily amount to a mistake in the identity of the accused, especially when sufficient evidence is adduced to show that the accused is pointed to as one of the perpetrators of the crime. In other words, class, the fact that there was a mistake indicated in the name of the accused is not a sufficient reason for the acquittal of the accused. That is not amounting to acquittal or a ground for the dismissal of the complaint or information. No? Because a mistake in the name of the accused is not a mistake in the identity of the accused. Those things are different. Now, name of the offended party. The complaint or information must state the name and surname of the persons against whom or against whose property the offense was committed, or any appellation or nickname by which such person has been or is known, and if there is no better way of identifying him, he must be described under a fictitious name. Class, in the same way that the name of the accused is not absolutely required, the name of the offended party is likewise not absolutely required. If the name of the offended party as a matter of fact is unknown, then you can identify him or use a fictitious name, no, in the same manner as the rule to the name of the accused is concerned. Okay? Now, in crimes against property, if the name of the offended party is unknown, the property must be described with such particularity as to properly identify the particular offense charge. For example, class, hindi nyo alam kung anong pangalan ng private offended party, you can describe the property subject of the offense. No, anong ibig sabihin dito na as to properly identify the particular offense charge? For example, class, you can describe the property as a personal property or real property, no? Consisting of a parts of, for example, consisting, if it's a real property, no, consisting of for example, or personal property, for example, a car, no? Because if you have described the property as a car or a motor vehicle or a motorcycle class, it will identify the particular offense charge as what? Carnapping, no? Or for example, what has been the subject of a theft is a goat or a carabao or a cow. What is the offense committed? Cattle rustling. No, cattle rustling. There's no such thing as theft of a goat. The proper charge therein must be cattle rustling. No? You learn this in your criminal law. So class, if the name of the offended party cannot be ascertained, then you have to describe the property subject of the crime. Now, if the true name of the offended party is thereafter disclosed or ascertained, then you have to insert to the complaint the real name of the private offended party. On the other hand, if the offended party is a juridical person, for example, a corporation or a partnership or a cooperative, these are juridical persons. It is sufficient to state its name or any name or designation by which it is known or may be identified without the need of averring that it is a juridical person. Because class, in the study of commercial law, no, or corporation law, you will learn that a juridical person is a personality on its own, no? A corporation has a personality or a juridical personality of its own, separate and distinct from the persons composing the corporation. So since the corporation is a person in the eyes of the law, then the private offended party is the corporation in itself and not the stockholders. So class, if you are preparing a complaint, do not write down the names of the stockholders. It is sufficient to write the name of the corporation in itself. Okay, if you will go deeper under Section 35 of the Corporation Code class, although this is not this is not part of your course, but a related topic, under Section 35 of the Revised Corporation Code of the Philippines, a corporation can bring suit under its name. So that is one of the express powers of the corporation, which is why if the private offended party is a corporation, suffice it to state the name of the corporation. Okay. Now, how about particularity of the date of the commission of the offense in the complaint or information? This is a recurring question, no, in the exam or even in practice class. Now, question. For example, if the crime have happened in the past or for several years before a complaint is filed, it happens, no? Minsan, yung private offended party is reluctant in filing a complaint in court for some reasons personal to him or to her. No, the complaint is filed several years after the commission of the crime. So sometimes the private offended party has already forgotten the exact date of the commission of the offense. Now question, can you write down or can you specify the date or only the month and year or only the year of the commission of the offense? Is the exact date of the commission of the offense required insofar as the complaint or information is concerned? As a general rule, class, the exact date of the commission of the offense is not required to be specified in the complaint or information. As a matter of fact, it suffices that the allegation approximates or be as near as the actual date when the offense was committed. No? So, pwedeng ilagay doon on or about. Yan ang mga ginagamit na phrasing. On or about September 20, 1990, etc. etc. No? Exception. Now, there is an exception to the general rule where the exact date of the commission of the offense is required to be indicated or to be specified in the complaint or information. Now, what is the exception? If the date of the commission of the offense constitutes an essential element of the offense. No, I will repeat. If the date of the commission of the offense constitutes an essential element of the offense, then you are required to indicate the exact date of commission of the offense. Now, what are the offenses where the exact commission of the offense is an element of the crime? In the crime of infanticide, abortion, and bigamy, class. These are offenses where the elements, where the exact date of the commission of the offense is an element of the crime. The crime of infanticide, the crime of abortion, and the crime of bigamy. Now, the time element of the commission of the offense is an element in itself. Now, the time of element or the date of commission is part of the essential element or essential ingredients of the offense, which is why in these crimes of infanticide, abortion, and bigamy, you have to specify the date of commission of the offense. Okay. Now, you will ask class, bakit kaya in these crimes, kailangan ilagay yung exact commission, exact date of the commission of the offense? Kasi class, for example, in the crime of bigamy, the crime of bigamy is what? The gravamen of which, for example, is a person has entered into a contract of marriage twice. Nagpakasal siya twice. Or 3 times. Class, sa batas natin sa revised penal code, kahit 3 beses ka magpakasal, bigamy pa din yan. Di ba? Ibig sabihin ng bigamy, there are 2 marriages. But under the revised penal code, kahit 3 or 4 na beses, bigamy pa din. No? Bigamy pa din ang tawag natin. Okay. Because class, the date of the commission or the date of the celebration of the marriage, no, will determine if 2 marriages will coincide. If the first marriage and the second marriage will coincide with each other, then the crime of bigamy is committed. Which is why, in the prosecution of the crime of bigamy, you have to specify the particularity of the date of the commission of such offense. Otherwise, there will be insufficiency in the complaint or information. Now, the remedy against the indictment that fails to allege the time of commission of the offense with sufficient definiteness is a motion for bill of particulars under Section 10 of Rule 116. Now, what is the remedy? If in case the complaint or information will fail to specify the offense committed by the accused, then you file a motion for bill of particulars. No, bill of particulars. Now, the failure to move for specification or quashal of the information on any of the grounds provided by the rules will be deemed as a waiver on the part of the accused. Okay. Now, so after discussing the date of the commission of the crime, we will discuss how about the place of the commission of the crime. Are you required to allege with sufficient particularity the place where the crime was committed? Okay. Okay. As a general rule, the complaint or information is sufficient if it can be understood from its allegation that the offense was committed or some of its essential ingredients occurred at some place within the jurisdiction of the court. Last day class, we have settled that every trial courts have their own territorial limits or territorial jurisdiction. No? For example, a regional trial court in Binyan can only entertain cases which have the elements that happened in Binyan City. No? The regional trial courts in Binyan City cannot take cognizance of cases where the elements or where any of its essential elements did not transpire in Binyan. So as a general rule, the complaint or information is sufficient if the allegation would include that the elements of the crime have occurred at some place within the jurisdiction of the court. There are exceptions. Okay? One, when the place of commission constitutes an essential element of the offense, charge, or is necessary for its identification. For example, class, trespass to dwelling. No, trespass to dwelling. In trespass to dwelling, the crime is committed when a person will enter into the dwelling or house of another, a private property belonging to another without permission. No, ayun ang tawag ng trespassing. No, commonly known as trespassing. Trespass to dwelling. Now, if the crime is trespass to dwelling, then the complaint or information must include with particularity the exact address where the crime was committed. Kasi class, the place in a trespass to dwelling is an essential element of the crime. The place must pertain to the private property of another person or the complainant. Which is why, if the crime charge is trespass to dwelling, then the complaint or information must include the specific place of the commission of the crime, which must pertain to the dwelling of the private offended party. Now, let us go to the designation of the offense. What do you indicate as the offense charge? Diba, class? If you get a hold a copy of an information or a complaint, nakalagay dun sa caption, sa taas, Republic of the Philippines, for example, 4th Judicial Region, and then Regional Trial Court. And then, sa baba, naandun yung parties involved. People of the Philippines, plaintiff versus X, accused. And then dun sa right side, naandun ang criminal case number, no, which is assigned by the docket of the Office of the Clerk of Court of the Regional Trial Court or the MTC as the case may be. Now, below the criminal case number is the designation of the offense. For example, our violation of RA 9165 or the Dangerous Drugs Act. Or for example, violation of Republic Act 9262. Ano yun? VAUSI, Violence Against Women and Children. Yun ang tinatawag nating designation of the offense. Now, the designation of the offense given by the statute must be stated in the complaint or information with the averment of the acts or omissions constituting the offense and specify the qualifying and aggravating circumstances. If there is no designation of the offense, reference shall be made to the section or subsection of the statute punishing it. Now, kayo, mga police officers, mga soon-to-be police officers, you have to remember that the complaint or information must contain the specific designation of the offense as provided for by law. For example, nakalagay, Section 5 or Section 11, no, illegal sale or illegal possession of dangerous drugs. Dapat ilagay niyan, no, illegal sale of drugs or illegal possession of dangerous drugs. Or if there is no specific designation of the offense, then it will be sufficient if you include violation of Section 5 RA 9165. Or violation of Section 11, RA 9165. No? If there is no designation of the offense in the law itself, then it will be sufficient if you designate the particular section or subsection of the law violated. Now, do not forget, class. Do not forget to include the qualifying and aggravating circumstances. You learn this in the study of criminal law, yung mga qualifying and aggravating circumstances. What are qualifying and aggravating circumstances? These are modifying circumstances. Di ba, naaral niya pag sinabing qualifying, for example, class, a person is killed using a firearm. Now, if a person is killed using a firearm, automatically the charge will be qualified from homicide to murder. Kasi the use of firearm is a qualifying circumstance. Instead of homicide, that homicide will now be murder because of the use of the firearm. Now, the use of the firearm must be stated, must be indicated, specified in the complaint or information because it is a qualifying circumstance. Pati yung mga aggravating circumstance, class, that you have learned in the study of the revised penal code, you have to specify them. Otherwise, class, if you fail to specify in the complaint or information the qualifying and aggravating circumstances, then even if later on during trial you are able to prove them, they will not be appreciated by the court. Ha? Tandaan niya ang class, ha? Pag hindi nyo nilagay ang qualifying or aggravating circumstance sa complaint or information, even if you are able to prove it during trial, the court will not appreciate those circumstances. The court will not appreciate, for example, the court cannot convict the accused for murder if you fail to specify the qualifying circumstance of the use of a firearm. Ano-ano ba yung mga aggravating circumstances na yan? For example, the use of superior strength or treachery. Yan, mga aggravating circumstances. Aggravating circumstances under the revised penal code has the effect of increasing the penalty. It can be an ordinary aggravating circumstance or a privilege aggravating circumstance. No? Okay. Now, the thing here is that you have to specify them in the complaint or information. Now, what if there is a conflict between the designation of the crime and the recital of the facts constituting the offense? The title of the information or designation of the offense is not controlling. It is the actual facts recited in the information that determines the nature of the crime. Now, for example, class, minsan kamamadali, di ba, nakalagay doon Section 5 or Section 11. Pero yung recital doon sa body ng information would pertain to a separate offense of Section 12 of RA 9165 or yung illegal possession of drug paraphernalia. Now, halimbawa, there is a conflict between the body of the information and the designation of the offense in the caption. What will be controlling is the body of the information. It is the actual facts recited in the information that determines the nature of the crime and not the caption or the title. Okay? Okay. Now, class, can the accused be convicted of a crime more serious than that named in the information? For example, class, the information provides homicide, no? Kasi walang qualifying circumstances. Now, if the accused is charged with homicide, can he be convicted for the crime of murder? No? If he was indicted for homicide, can the court finds the accused guilty of the crime of murder? Answer, no. No, no, no. The accused may be convicted of a crime not serious than that named in the title or preliminary part if such crime is covered by the facts alleged in the information and its commission is established by evidence. Even if during trial, you are able to prove that the accused is guilty of murder, if the complaint or information would charge him of a lesser offense of homicide, he cannot be convicted of murder. No, tatagalogin ko class, no, para maintindihan ninyo. Kapag ang demanda, ang akusasyon sa akusado ay homicide, hindi siya maaaring makonvict ng murder. Because murder is more serious than homicide. On the other hand, class, if the accused is charged with murder, can he be convicted of the crime of homicide? For example, reverse naman na nangyari. Ang dinimanda mo is a more serious offense. But evidence would prove that he committed a lesser offense of the crime of homicide. Can the court convict him for the crime of homicide, a lesser offense than the crime of murder? Answer, yes, yes, yes. The accused may be convicted of a crime not serious than that named in the title or the complaint or information. Ha? Tandaan yan. Okay. Now, there are exceptions. An accused could not be convicted under one act when he is charged with a violation of another if the change from the statute to the other, number one, involves change in the theory of the trial. Number two, requires of the defendant a different defense or surprises the accused in any way. So these are the exceptions. Under these exceptions, no, even if the evidence would pertain to a lower offense, the accused or the court may not be able to convict the accused to a lower offense. Kasi class, baka mamaya the lower offense would involve a change in the theory of trial. For example, eto na yung defense ng accused, pero dahil iba yung conviction, magkakaroon ng violation of due process because the accused was not apprised of the acts or omissions charged of him. Ibig sabihin, nagbago na yung nature ng offense. No? For example, the accused was charged with the crime of murder and he was convicted for the crime against property, for example, crime of robbery. Magkalayo na yan, class. Hindi na yan lower offense. No? It will change the theory of the trial. It will change the theory of defense. It will require the accused to present a different defense than that of the original charge. Which is why, class, even if the crime of, for example, theft is lower than the crime of murder, the court may not convict the accused to the crime of theft because it will require the accused to present a different theory of defense, or it will surprise the accused in any way. Okay. Now, cause of action. What is cause of accusation? The acts or omissions complained of as constituting the offense and the qualifying and aggravating circumstances must be stated in the ordinary and concise language. Class, as police officers or future police officers, you don't need to use the wordings of the law when you are writing or preparing the complaint, no, or the information. You don't need to use the precise legal terms. No, it will be sufficient if you have alleged the allegations in the ordinary and concise language. Okay? Okay. Now, bakit kaya kinakailangan lahat ng elemento ng krimen ay mailagay sa complaint or information? What are the purposes of requiring that every element must be alleged in the complaint or information? Number one, this will enable the court to pronounce the proper judgment. Number two, it will furnish the accused with a description of the charges as to enable him to make a defense. And number three, as a protection against further prosecution for the same cause. Okay. Now, what is the effect when one or more elements of the offense have not been alleged in the information? Halimbawa, yung isang element ng crime or essential ingredient of the crime have not been alleged in the information. As a result, the accused cannot be convicted of the offense charge, even if the missing elements have been proven during trial. Okay? Let us go to this duplicity of offenses. As a general rule, class, a complaint or information must charge only one offense. No? One offense, one complaint or information. That is the general rule. Isang krimen, isang complaint. Isang krimen, isang information. Kaya class, usually, kapag nagkaroon ng buy-bust operation sa drug cases, halimbawa may posture buyer, bumili ng droga, no? Tapos, nung nagkabilihan ng droga, dinakip na si akusado at nagkaroon na ng search within his person or within his body and within his immediate vicinity. Pwede kang mag-search dyan, mag-conduct ng search. Warrantless search. Diba? Pag nakita mo sa bulsa niya, meron ding sachet ng crystalline substance na tinatawag, which is suspected to be methamphetamine hydrochloride or shabu. Pwede mong i-seize by search and seizure of the contraband, no? Now, kapag dalawa ang offenses, illegal sale and then illegal possession because you were able to retrieve one sachet in his possession, not subject of the sale, then dalawa ang complaint or information. Kasi a single complaint must have single offense. Isang complaint, isang offense. That is the rule. Kaya dalawa ang information na ifa-file sa court. Isang information for violation of Section 5 and information for violation of Section 11. Dalawa. Because for every single information, there must only be one offense. Okay. There are exceptions to the general rule. Now, when the law prescribes a single punishment for various offenses, for example, in complex crime, special complex crimes, continuous crimes, or delito continuado. Class, pag special crime or special complex crime, kaiba yan, no? Or continuous crime or delito continuado. Class, isa lang ang penalty. Isa lang ang punishment. Although complex yung crime, maraming krimen na na-commit, isa lang ang penalty na ipinapataw ng batas. For example, class, robbery with homicide. For example, in the course of robbing a house, the owner of a house suddenly was awakened and then he was surprised by the offender, the robber, no? Nagising ang may-ari, nakita ang nagnanakaw at pinatay ang may-ari. Unfortunately, the complex crime of robbery with homicide. Actually, it is a special complex crime. Because there are two crimes committed. Number one is robbery, and in the course of robbery, there was homicide. Now, these are two offenses, but the law considers them as a special complex crime. No? Special complex crime. In the eyes of the law, there is a one integral crime called as robbery with homicide. Now, what is the penalty for that offense? There is only a single punishment, single penalty. Since the law prescribes a single penalty, even if in actua there are two crimes, then you can include that in one complaint or information. No? Number 4, crimes susceptible of being committed in various modes and crimes of which another offense is an ingredient. In these exceptions class, you can include them in under one complaint or information because the law gives them a single punishment. Okay. Now, if there is a duplicity of offense in the information, when you say duplicity of offense, class, ibig sabihin, In one information, there are two offenses charged. No? If there is duplicity of the offense in the information, unless a single punishment for various offenses is prescribed, the accused must move for the quashal of the same before arraignment. Ang remedy ng akusado is to file a motion to quash the information on the ground of duplicity of offense. Otherwise, he is deemed to have waived such objection and may be found guilty for the duplicitous offenses that were alleged in a single complaint or information. Okay, I think that will suffice for this afternoon. So next part, or the part 3, we will discuss about amendment or substitution of complaint or information. So that will be all for now. See you again next meeting. Thank you.